I'm joined now by the Attorney General of California, Rob Bonta. Thanks for joining me.
Thanks for having me.
So we have been tracking the very important case regarding the legality of Trump's deployment of federal troops into California. We now have a ruling on that case that was decided on the merits. Can you explain what just happened in court?
Absolutely. We got a order today from the trial court, the Northern District of California, specifically Judge Charles Breyer this morning, which affirmed everything that we argued to the court in a 3-day trial a couple of weeks ago. And the conclusion by the court is that the Trump administration's deployment of the military in Los Angeles, 4,000 National Guards people and 700 Marines, violated the Posse Comitatus Act, which prohibits the use of the military to engage in civilian law enforcement. So the court found that a long-standing federal law, a principle rooted in the founding of this nation, when a British monarch was using the military to police the colonies, that was violated by Trump, and that the National Guards people and the Marines were engaged in civilian law enforcement, things like perimeter support and blockades and traffic control and crowd control and riot control in apprehensions, all in violation of federal law. And the court issued an order saying that the military in California cannot engage in that conduct any further. So it was a big win for us.
Yes, it was a huge win, and something I've been talking about quite a bit lately. And I want to get into the implications in terms of why this is so important. But first and foremost, is there any indication as to whether this administration is going to appeal to the Ninth Circuit?
We fully expect them to, just based on their past behavior, their pattern of appealing all the time. We haven't seen one yet. We might see one later today, maybe tomorrow. I will say that Judge Breyer, the trial court judge, delayed the implementation of the order until next Friday at noon, September 12th. So they have until then to appeal before the order kicks in. And I think Judge Breyer has, is aware that there might be an interest in appealing, and he wanted to give them a window of time to do that should they decide that was prudent from their position.
Is there some concern, do you think, from the Trump administration side that if they do decide to appeal this and the Ninth Circuit rules in very much the same way that the trial court did here in Judge Breyer's court, that this would then not just be kind of atmospheric precedent or a legal framework to be able to do this elsewhere, but that would actually offer up precedent for other states to be able to fight back against this, which would go against what Trump is trying to do?
Yeah, I mean, they got to do their own risk assessment here. We think we're on really strong ground. We had a 3-day trial. This is a developed factual record with legal arguments over multiple days. The court took its time issuing a very thoughtful opinion here. We think that if it goes to the Ninth Circuit, it should be and will be affirmed, and by any appellate court. And these are just blatant violations, clear violations of a federal law that prevents the military from engaging in law enforcement on American soil against civilians. And Trump has declared and stated his intent to violate this law some more in multiple cities, all Democratic blue cities, by the way, completely partisan, completely targeted, completely weaponizing the military against his political opponents. He says he's going to use the military for tackling crime, which is civilian law enforcement, the very definition of it, in Oakland, in Chicago, in Baltimore. So yes, we believe this is an important precedent, an important blueprint, and could block any of these planned activities that Trump has articulated.
Is Trump using the basis that California fought in the courts as the same basis to deploy the troops elsewhere? So what I'm trying to find out is the ruling in this case, would that be analogous to the same defenses that other states could put up elsewhere?
It's very similar. The Trump administration relied on a federal statute that said that if there is a rebellion or the inability to enforce the federal laws, then the military could be deployed. And there was no rebellion. There was no inability to enforce the federal laws. But the Ninth Circuit, with its stay on Judge Breyer's order, striking down the original authority for deploying the troops, gave a lot of deference to the federal government. And that is likely what the federal government would be arguing, but they would be really fighting an uphill battle there. What Trump has said is that he wants to deploy the military to fight crime. And that's not a rebellion. That's not an invasion. That's not the inability to enforce the federal laws. Crime, as he uses it, those are state laws. And so he is basically saying that he is going to violate the Posse Comitatus Act. He's saying the quiet part out loud. He is declaring his intentions to break federal law before he does it. So I will also say Washington, D.C. is a unique animal of its own. There is a Home Rule Act right there. The president is the commander-in-chief of the National Guard. There's emergency authority to deploy military under certain conditions for 30 days. So D.C. is a little bit different. But I think that the ruling that we've secured here will be very impactful in any other city or state that faces the deployment of the military to engage in civilian law enforcement.
Have you spoken to other state attorneys general about the prospect of kind of using the legal framework that you used in California to fight back against this and adopting it in other states where we're virtually assured to see troop deployments, like Illinois, for example, New York, and I presume as we get closer to the election, states like Wisconsin and Michigan and Georgia and Pennsylvania?
I have, and the Democratic attorneys general have been, it's no secret, working together, partnering, collaborating, communicating, sharing information, sharing intel, relying on one another for the best insights and institutional knowledge and pathways forward. And so this case has been watched with great interest by other attorneys general who lead states that have been targeted by Trump, that Trump has declared he will, you're next. And so we have been in communication, and I know that they have reviewed the court order and the rationale and the interpretation of the Posse Comitatus Act, and I believe it will be very useful to other Democratic attorneys general pushing back against the unlawful use of the military in their states.
Are troops still deployed in Los Angeles? And I guess if they are next steps determined by what happens over the next few days in the courts? Like I know that Judge Breyer's ruling doesn't go into effect until a few days from now. And so I guess what happens on that front?
Yeah, of the original 4,700 military personnel deployed to Los Angeles, 300 remain. So in multiple phases over the last 90 days, or 60 plus days, the Trump administration started sending the troops home. Which was very appropriate to send them home and should have happened much sooner. The Trump administration was basically disrespecting these patriots and abusing them, treating them as political pawns and treating them as his political army for this political stunt and these theatrics. And they were better used, deployed to tackle wildfires and fentanyl as the National Guards people were, and their time was being wasted and they were violating the law when they were in LA. But 300 remain. And this order applies to them. They cannot engage in perimeter support, in blockades, in traffic control, and riot control, arrests, apprehensions, detentions, searches, seizures. So what will they be doing is a big question. And they can sit in federal buildings, protecting them from no threats if that's what the president wants them to do, and apparently that's what they are doing. But that is the only lawful thing of the articulated functions that the Trump administration seems to want them to play that we believe, based on our interpretation of the court order, that they can do. But I will say that there was a additional order deploying these 300 troops for an additional 60 days, and stay tuned. But we are very concerned about that order and are contemplating our next steps.
The way that I'm thinking about this is not necessarily just about right now, in terms of these troop deployments. The way that I'm thinking about this is that this offers kind of a basis for Trump to be able to normalize Americans to the idea of troops on the streets when it becomes a lot more politically useful for him, politically advantageous for him, which is close to the election. We know, for example, that Trump tried to have the voting machines seized in Georgia in 2020. We know that he tried to block certification of the election. We saw that there was an insurrection at the U.S. Capitol. And so we also know, though, that someone like Bill Barr was Attorney General, and even he, this is certainly not some leftist by any means. Even he said that Trump's stolen election claims were bullshit. But Bill Barr is gone, and he's been replaced by Pam Bondi. And, we've got folks like Dan Bongino and Kash Patel at the head of the FBI. And so there are no bulwarks against his overreach in the Justice Department or at the FBI. And so my worry is that with a green light in that respect, having boots on the ground will allow him to kind of carry out the more nefarious plans that he tried and failed to carry out in 2020. And so how are you and other attorneys general thinking about these troop deployments with regard to the elections, both 26 and 28? And how is that kind of informing how you're litigating against this whole thing?
Absolutely. That specter looms over all of this. And the impact of the military, the chilling effect, the intimidation, the trauma imposed by them to chill elections and to shape outcomes of elections. It's very problematic. And you're right about who is in occupying these key positions. It's apologists and supplicants and loyalists who will do whatever Trump says, regardless of the law. And we need more folks to stand up and speak up and speak out about what the law requires. Like one of the witnesses that we had at our trial in this National Guard case, who what raised concerns internally. He testified about the possibility that they'd be violating the Posse Comitatus Act with some of their planned actions and initiatives. And someone else in and the Trump administration questioned his patriotism because he was not blindly loyal to Trump and dared to question the legality of a proposed initiative. I'll also say that the additional 60-day deployment of the 300 troops in LA would take them past Election Day in California on November 4th. Is Election Day, and they would be deployed till November 6th. In LA, we find that very problematic. We think that troops on the ground during an election is very problematic to democracy and to participation in a free democracy, and can harm and undermine the right to vote. So, but you're right, this idea of socializing and normalizing troops by deploying them in more places, more often, more frequently for reasons that are not appropriate under the law. I think the belief is that people will get used to seeing the military and will get okay with seeing the military. But it is not okay. And more importantly, it's illegal. And that's what the court found today.
Very quick question. What was the legal basis that he used to be able to deploy these troops?
The original basis that Trump used to deploy the troops over 60 days ago now was the inability to enforce the federal laws with the regular forces.
So if that was the basis that he used, is there the possibility that he can choose a different legal basis, recognizing now that this one won't be able to stand in court? I mean, it was just struck down by Judge Breyer. Is there a different legal basis that he could use? And is the fact that he landed on this one first, does that suggest that this was his strongest argument? And so if he does try to use a different legal basis, inherently it'll be even less potent, less persuasive, less well-founded than the one that he used right now?
I think you're right on the justification. The one that he relied on here is the lowest threshold, the easiest to meet, let's say. The others are the presence of a rebellion or the presence of an invasion. Nothing close to that here or in any of the other places that Trump is talking about deploying military to. So he used the lowest threshold justification here. And the Ninth Circuit did stay our court order saying that justification was improper. So he might try to use that justification again. But whatever the justification, today's order says that the military cannot be used to engage in civilian law enforcement, can't be involved in arrests and detentions and apprehensions and searches and seizures. And that is precisely what Trump seeks to use the military to do in all the other cities that he is threatening to deploy the military to. So he clearly cannot do that without whatever the justification he seeks to advance for why they're being deployed.
Well, Attorney General, I appreciate the work that you've done in the court to block this thing. We'll be keeping an eye on what happens with regard to whether he opts to appeal this thing or not. But thank you for your time. I appreciate it.
Wonderful to be with you. Thanks for having me.